And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and I'm here every Monday at 10 a.m. Pacific time to talk about estate planning and trust and probate administration from the standpoint primarily of professionals like myself. As you know, I do this for a living, but also for those of you who you don't do this on a regular basis. Maybe you were made the executor of, your parents' will or something like that, and now you're trying to navigate your way through this confusing and often aggravating process. And so now you'll have a source of information and be able to talk to your advisors more cogently. So today I'm going to be talking about dealing with parents who are resistant to creating an estate plan. So, in my work, I was thinking about this earlier today. Uh, I kind of sometimes feel like, I don't know, the Grim Reaper or something, because at the point where I'm asked to step in and administrate a probate, okay, it is much more likely to be one where the decedent has died intestate, meaning there's no trust, there's no will, there's been no estate planning done, number one. And number two, oftentimes as a result of the lack of an estate plan, the heirs or the beneficiaries are now in disputes. And so the court finally says to them, look, just bring in a professional and let's get moving with this. But that typically takes at least 9 months and sometimes a year or more of, sort of not floating, but bouncing around the court while the judge, gives the heirs time to figure it out on their own, which doesn't seem to happen very often. So, this is a real issue with real world consequences for all the people involved. And I will say at the outset, because I don't think I have this. I don't have this on the points that I'm going to be talking about, that I'm going to be going over today. The reality is, for the vast majority of people, maybe for everyone, the cost to die intestate is less than the cost. I'm sorry, is far greater than the cost of doing a proper estate plan. And when I say a proper estate plan, I don't mean going to a do-it-yourself service or, going to, Perplexity and saying, draft me a will. Okay. Most of us do not have anything like the legal background and financial sophistication that would enable us to use a large language model to draft a will for us and know whether that will has been properly drafted. Okay, so a basic estate plan, $3, $4, $5,000, something like that. The cost to administrate an estate is going to be multiples of that. Okay, the what are called the statutory fees on a I'm going to give you an actual example. Okay, so the statutory fees on a $1.4 million estate for the administrator, they're $27,000, and for the lawyer, they're $27,000 here in California. In other words, the statutory fees are $54,000. That doesn't include costs for filing the probate, which could be another several hundred or $1,000. Okay. So you could easily pay $60,000 to administrate a $1.4 million estate when someone has died intestate, as opposed to the cost of doing an estate plan, which is probably going to be in the range of about $5,000. Now, it'll depend on the assets and the family situation and a number of other issues, but there is virtually no chance that the cost to do an estate plan on a $1.4 million estate here in California are going to come anywhere close to $50,000, let alone more than $50,000. Probably a fraction of that, 20% of that at the most, I would say, okay, based on my experience. So, for financial reasons alone, everyone should get an estate plan, or everyone with any kind of appreciable assets. If you have a home, you have a large stock portfolio, and uh, other assets like that. So you need an estate plan. And let me add, as many of my guests have mentioned, an estate plan is not just dealing with financial issues. So there are other documents in a properly created estate plan to deal with your health, your well-being, if you should, God forbid, become infirmed, other to deal with other issues like how end of life decisions are going to be made, how what your burial or committal plans are going to be. So there's a number of other issues that get covered in an estate plan besides financial ones. Okay, so having said that, the reality is that aging parents oftentimes are nonetheless resistant to doing an estate plan. I'm going to talk about several of those issues, and offer some thoughts on how they can be dealt with. So, first of all, let's try and understand, why are they refusing help? Why are they, why do they not want to deal with this? So, from the standpoint of adult children who may be urging them, you may be urging your parents to create an estate plan. Resistance many times is about fear of losing control, not, what we used to call orneriness or stubbornness. I mean, maybe your parents are stubborn, but in this case, beneath that, oftentimes is a sense that I'm losing control of my life. It's very similar to why older people uh, hang on to having a driver's license, even if they've already stopped driving. So there's someone in my family hasn't driven for literally years and years, maybe 10 years at this point. Okay, still keeps her driver's license, and it's fine. Okay, she's told me flat out, not interested in driving anymore. Don't want to. Okay. Gave up her car a few years ago. Okay. But her driver's license, that's different, right? She could get what's called a California ID, which provides identification without the privilege of driving, but she wants a driver's license. Okay. Because losing that driver's license, or not having that driver's license, would feel like, I think, she's losing control of her life. Okay, and I think we should all be able to understand that. I don't think, let's not be so callous as to think that, somehow we're easily going to give up our sense of freedom or our sense of control over our own lives when others, will not. Um, and so, if you're a child of a resistant parent, pushing harder often creates even more distrust, or creates distrust. and makes the parent feel like they need to do things in secret. Okay. So we need to help our parents hear the message that we're here to help them make their life easier and relieve them of burdens. This is not about them losing control. Okay. In the case of my relative that I just mentioned, uh, I now handle her, not all, but her, most of her business affairs. And uh, without getting into too much of the family dynamics, I just said, hey, if I can help you, that I want to do that. Yes, I do this for a living, but this isn't about me, doing anything other than helping you out. And just know that if you do ask me to take on these various, duties or whatever you want to call them, that doesn't mean that you're out of the loop. Quite to the contrary. I'm going to treat this just as I would any other client, where I'm going to report to you on a periodic basis. So you're going to know what's happening. It's just, you're not going to be bothered with actually doing it. And if something needs to be done, you can just call me up and say, Kevin, do this. Okay. And I'll do it. And the fact of the matter is, I'm happy to do this for her. This is someone who has, throughout my life, been a very important person to me, and I want to relieve her of burdens if I can. But I don't want her losing control, because it's still her life. Okay, and that's, I think, what we need to keep in mind as adult children or adult relatives of somebody. This is, I'm not talking about my mother here, just to specify. Now, from the standpoint of professional advisors, so um, we can expect um, resistance to come from kind of a similar place. Our clients may feel they're losing their identity. Okay. And that's a tough thing for any of us to face. So it's not fear of cognitive decline, although there may be some of that involved. So we have to be, I think, open to the same kind of language and explain to an older person, look, we're here to support you. Okay, we're not exercising oversight on you. That's not what's going on here. Okay, we're here to help you, to make your life easier. Okay, but it's still your life. Okay, and what I do is take your decisions and make sure that those decisions are carried out. And that hopefully will make it easier for you. Okay? So I think that both adult children and advisors oftentimes underestimate how threatening the process feels. And so, in their zeal to, get it done, okay, they overlook the emotional aspects of this. And this is where, candidly, my background as a military chaplain, I think, helps a lot. There's almost always an emotional component to these kinds of issues, and we need to keep that in mind. Okay, next, how should we approach the conversation, right? So, I mean, do we just want to, blurt it out? That may not be, such a good idea. And so I've got a few tips here. I'm sorry, I'm adjusting my notes so they're easier to see. There we go. Okay, come on. There we go. Okay. Um, so some suggestions on how to approach the conversation. So first of all, um, start early. Okay, don't wait for things to hit a crisis point. so that now there's tremendous urgency to get it done because uh, the person, the family member, the parent may just not be ready to move that quickly. And again, going back to the first thought, pushing them will only make the situation worse. So, you know, start talking to your parents about it early on, long before there's any crisis need for it. Next, ask them questions instead of proposing solutions. So, a question would be, what worries you the most about what will happen after, God forbid, may it be a long time from now, you pass away? Um, what do you want to happen when you're, unfortunately no longer with us? How how do you want your life to be as you transition from where you are now to maybe a place where, and we all, this happens to all of us, things are more difficult for us to accomplish, right? So ask questions that are empathetic, okay, but it gives them an opportunity to think about these issues without a solution staring them in the face. Okay, give them some time to become comfortable, if they haven't already, with their own mortality. We all have to do this. I know I went through that process myself. When I was younger, the thought of death on a certain level was pretty frightening to me. I wasn't married yet, but I knew I wanted to get married. I wanted to have children, and the thought that I would die before I got to do that, and was very disturbing to me. And so it's not any less so for someone who's not young, and in fact, the you know, being closer to that eventuality uh, could could be worse. Okay, unless there's been a working through. So um, position yourself as a backup, not as a decision maker, like I did with my relative. I'm just here to help you. If there's things that I can do to take the burden off of you, that's what I'm here for if you want it, okay? But, I'm not the one who am going to be making decisions about your life unless you want me to. If there's something you don't wanna have to deal with it and you say, "Kevin, you decide," fine. But I'm only doing that because I wanna help you, I wanna be a backup to you. So for adult children, that I think is the best way to approach this issue. For professional advisors, so we want to reframe the engagement around preserving their independence and choice, right? We're here to serve you, to make sure that what you want to happen will happen, or at least give it the best shot at happening. Okay. Uh, you know, that's our job, to see to it that your wishes are fulfilled. Okay. And again, to preserve your independence, right? So again, estate planning is more than just what happens with my money after I die. It's what happens in my life as maybe I start losing some of my abilities, right? Am I going to move to a congregate care facility? Am I going to move to a retirement community? All of these are questions that we all are going to need to answer at some point in our life. And the sooner we think about these things, ask the questions that need to be asked, get the advice we need to have, because most of us are just not experts in all this stuff, the better are the chances that we'll be able to preserve our independence, or at least more of our independence and choice. So we, as professionals, we can use scenarios of what could be, okay, rather than using sort of present day criticism. Why don't you have a will? Why don't you have a trust? Why don't you have an estate plan? Well, the answer to that is because I don't. I haven't done it. I'm afraid of doing it, whatever. There's no point dwelling on that. So, you know, what do you want your retirement to look like if you're planning to retire? What do you want the latter part of your life to be like? How do you want to engage with your children, your business associates or former business associates? How do you want all that to look? I'm here to help you make that happen as much as possible. Okay. So, as a professional advisor, we can serve as a neutral third party between the client, the aging individual, and the client's children. Okay, so that that if there has been some conflict, we can arbitrate between them and hopefully lower the temperature and make some good progress. Okay, all right, let's take a quick break. We'll be back for more. When life brings unexpected changes, managing inherited property shouldn't add to your stress. Magnum Properties specializes in probate and trust real estate management. We handle the complexities while you focus on what matters most. From property maintenance to tenant relations, from legal compliance to maximizing value, we're your trusted partner through every step. Magnum Properties Inc., turning property challenges into peace of mind. Call us today at 213-264-4396 or visit magnumprops.com. Okay, so what are some warning signs then that legal risk is increasing, right? That you're getting into crisis time and maybe don't have the luxury of leisure with which to deal with this situation. So, for adult children, if you see bills piling up, if you start to hear about strange uses of money or new helpers handling money. So I have a very long-standing friend whose father, who he's deceased now, but at the time he was alive, and it got to the point where he could no longer live in his house alone. And so first they got someone to live in the house with him, and then it got to the point where he just couldn't live in the house. He had to go live in more of a retirement home. And my friend started hearing from his father about how his caregiver was handling certain aspects of his finances. And, good for my friend, he looked into this pretty quickly and found that the caregiver was stealing money from his father. And if he had let it gone unchecked, his father could have lost much more than he ended up doing so, right? So you know even if our parents don't have an estate plan, we have to keep our radar up, keep our spidey sense, right? Spider-Man, about these kinds of issues, because at some point it's not just that the estate will be deleted, the money will be lost from the estate. It's that your parent will not be able to afford to live. Okay, so if there's sudden secrecy or anger when finances or health are mentioned, again, that may mean that there's something going on that puts your parent at risk. There could be some kind of elder abuse going on. We tend to think of elder abuse as being physical abuse of the person, but that is not the case. Financial abuse is as real and perhaps more frequent than physical abuse. Okay. And if there has been an estate plan created, but now your parent is reluctant to sign the documents, or maybe they won't engage in updating the documents. So that too can be a warning sign that there's increased legal risk afloat. And then as adult children, what do you do? Um, from a professional's perspective, so um, we need to be looking for fact patterns that suggest undue influence or financial exploitation. Okay, again, this is a form of elder abuse. And, uh, one of the questions we should be, asking is, how are you currently handling your finances? Oh, I write all the checks myself, and I sign them all, and I put them in the envelopes, or whatever. Okay, sounds fine. Oh, my caregiver is a signer on my checking account. Ooh, what? Who's your caregiver? Oh, well, she comes in each day for a few hours and takes care of things. Really? How often do you see your bank statement? Oh, she takes care of that. Now, by the way, there may be nothing wrong. The caregiver could be absolutely honest, but verify, right? Make sure that everything is being done correctly on the up and up, as we say. Okay. Um, if the potential client or the client is exhibiting some cognitive lapses, so they may not meet the incapacity standards, but they may not be 100% there. So again, legal risk is increasing. Okay, both the chances that they'll make a mistake or they'll forget something, and that they're in a position to be to be exploited. Um, Finally, um, family dynamics can increase legal risk, can increase the risk of litigation. It can increase the risk that if a conservatorship has to be created, that disputes will arise out of that conservatorship. And so watch the family dynamics as well. How are things going with your children? Have you seen them recently? How are their lives going? Et cetera, et cetera. How are things going with your spouse? Right? Those are the kinds of questions we want to ask potential clients. Okay, so what tools can we use to add protection without taking over? So, for adult children, limited powers of attorney can help without removing complete control. Okay. So, perhaps someone can, an adult child can be given a limited power of attorney to handle everyday bill paying. Okay. But that power of attorney will not allow the adult child to make major financial decisions. Maybe that's a good way to get started. Okay, so the parent can get used to the idea of letting someone else help them without really losing any control. Okay, so routine matters are routine matters. You can report to them monthly or whatever, and they're fine with that. So that's one tool. Another tool is to set up a trust, where the trust and the terms of the trust can act as guardrails rather than restraints. Okay. So, again, in a trust, assuming that maybe as an adult child, you're going to be the trustee rather than the grantor, your parent being the trustee. So the trust language can be written on a narrower basis so that your parent, at least for, at the initial stages, can feel like they're retaining control, which they are. And yet you have enough authority within the terms of the trust to fulfill whatever duties you have with respect to helping your parent out. Okay. And then the other aspect of this is so the other aspect of this is that make sure, if you're going to use any of these tools, that siblings' roles are clear in order to reduce conflict between siblings and prevent accusations later on the part of siblings or even your parents that somehow, the situation, you took advantage of the situation. Okay. So talk all of these things through prior to taking any action. Okay. Give people an opportunity to voice their concerns, and how and be part of putting together a plan that everybody can basically support. Okay. So, from the standpoint of professional advisors who may be called upon to actually enact some of these tools, like a limited power of attorney or a trust, right? So, they can draft narrowly tailored documents with limited authorities that will withstand court scrutiny were there to be a dispute in the future, and one of the interested parties decides to drag this whole thing into court. Okay. So they can professionals, because they do this all the time, so they can anticipate how documents will be reviewed, will be not reviewed, will be viewed in hindsight if litigation results. Okay. So they should be able to look at it now in the present, but also give some sense as to how the perceptions of these documents will age and change over time. That's part of their job. And it's also part of their job to periodically determine whether such documents need to be revised. Okay. And explain that that's part of the process. So, whatever we're starting with now is not forever and all times. So, it could be that after working under the documents for a year, that you'll realize, hey, these are too broad, and we need to narrow them further. Or maybe they find out, no, they're too narrow. My child, or in a power of attorney or as a trustee, needs more authority to really be able to help me out. Okay. So the professionals can make that call about balancing flexibility, um, and accomplishing the goals of the estate plan, with the least restrictive intent. Okay, so to meet the ability of everybody to best handle the situation as it exists. Okay, so that's very important. Okay, let's take another break. Be right back. Probate and Trust TV, your curated source for the most useful and insightful content on estate planning and trust and probate administration, featuring standout professionals like Bill Gross, Paul Brabelet, James Cunningham, and yours truly. Whether you're a lawyer, accountant, real estate professional, or working on your own succession plan, this channel helps you quickly find the clearest, most practical content YouTube has to offer. Subscribe now to Probate and Trust TV. Spend more time learning, less time searching. Okay, so now let's look at what do you do if crisis has arrived and no estate plan is in place and some kind of action needs to be taken in order to make sure that the situation does not spiral completely out of control? So one option may be looking at a limited conservatorship. Okay. Now, there are basically two aspects, if you will, or two types of conservatorships. There's a conservatorship of the person, and there's a conservatorship of the estate. So, a conservatorship of the person is where the person's personal needs, their health, their well being, their personal well being, is handled by a conservator. Conservatorship of the estate covers their financial well being. Now, there are conservators who do both. Okay. Uh, but what I found is, unless you're talking about a large organization that's acting as a conservator. So when I had my real estate company before I joined the Navy, Jewish Family Services here in Los Angeles had a conservatorship program. And it was a whole team of people to handle both conservatorships of the person and of the estate. Now, even with that, when they needed specialized advice or specialized when they had special issues with which they needed to deal, they called in specialists. And so I oftentimes was called in when there were real estate issues. So, for example, if they had a property that needed to be managed, my firm managed that property on behalf of the conservator. When there was consulting on what to do with real estate, they would call me in, and I might do an appraisal, or I might do a consultation, or whatever, to help them make a better decision. Okay, so even for and again, this is what I don't recall how many people were on the staff, but it was quite a number of people. Okay, outside of that, for an individual to have a high level of competence in both those categories, the person and the estate, I would say is unusual. Okay, now I know here in California, where we have to be licensed to act as conservators, at least as individuals. So a lot of the people who get a professional fiduciary's license actually come out of the healthcare arena. They have little, if any, experience in acting as what might be kind of a business manager for other people. And so they're very qualified to be a conservator of the person, but they're not qualified to be a conservator of the estate. And that would be the opposite of me. So I'm qualified to be the conservator of an estate, but I do not have the knowledge, skills, or experience to be a conservator of the person. And so when presented with a conservatorship situation, I may always make that clear up front. And then if there is a way I can help with my background, I will. But I would never become the conservator of a person where I would be both the conservator of the person and the estate, because I could not do the other half. I could not do the conservator of the person half. Okay. So conservatorships also don't need to be forever. So they can be established and they can be disestablished. Okay. So they can be, in other words, temporary. So it's not a, lose all rights or nothing alternative. Okay. It can be a conservatorship over just some aspects of the person or estate, or it could be a broader one. It depends on the situation. It can be a temporary conservatorship. It can be a permanent conservatorship, although technically there's really no such thing literally as a permanent conservatorship. A conservatorship here, especially here in California, can only last as long as the person needs to be conserved. Okay, so That's just something to keep in mind. So as I was saying, it can be focused on one issue like bill paying or medical consent. Okay. Um, and it's often used as kind of the choice of last resort when someone has a parent who just won't accept help but is in real danger. Okay. Maybe they've been financially abused several times, and if it happens again, they're really going to be in deep financial problems. And so then an adult child may have to file for an involuntary conservatorship. Okay. Now, by the way, I should mention that conservatorships can be voluntary or involuntary. So an individual can place himself voluntarily under a conservatorship. Okay, he can, in essence, petition the court to do that. Other times it would have to be done involuntarily. Obviously, that's more difficult to accomplish. Okay, from a professional advisor standpoint with respect to limited conservatorships, so um, courts increasingly um, want to see evidence that this type of alternative was tried first before they will consider ordering a full conservatorship, right? And in uh, there's an organization called PFAC, the Professional Fiduciary Association of California. So in their code of ethics, okay, it requires people who belong to that organization to not conserve more issues than need to be conserved. Okay, and that's, I think, that's an absolute best practice. And courts, I think, should be skeptical about placing someone under a full conservatorship when in a situation where a more limited one hasn't been tried. Now, we can certainly come up with circumstances where the first conservatorship needs to be a full conservatorship, but generally speaking, that won't be the case. And especially if we're proactive in working with our parents or as advisors with our clients to avoid absolute crisis. Okay, a limited conservatorship should be tried first. So uh, you know, in these cases, precision matters, right? If a person if an overbroad conservatorship is proposed from the get go, that can cause a great deal of skepticism, resistance, fear, which can delay the process more and end up causing more harm. So even if you may think that a full conservatorship is the right solution, it's probably not best to initiate the discussion on that basis. Rather, initiate it on a limited basis to help the person get used to the idea. So I was helping out a client of my sister. My older sister is a therapist who was having a number of difficulties. And one of the things we discussed was putting her voluntarily going under a conservatorship. And I explained to her that, first of all, if it was something that I was going to handle, or a role I was going to fill for her, it would have to be limited in scope. I wouldn't take on a full conservatorship because, for as I mentioned a moment ago, I don't do conservatorships of the person, and I wasn't in her case, I wasn't sure that that was necessary. She was under a therapist's care, etc. But I said, even then, this wasn't something that I was prepared to say has to be in essence permanent. It would be a temporary measure to help her get through a difficult period in her life. And after that, presumably the conservatorship would be dissolved and she would go back to handling things herself. Now, I'm not sure, honestly, that would ever happen, that she would be able to take things on. But I wouldn't go into a situation saying, no, once we establish this, that's it, it's done. I don't think that's a wise thing to say. And it's not provable. We can't predict the future that's certain with that kind of certainty. Okay. And so again, as professional advisors, we need to be empathetic. We need to consider the emotional dimension of these issues as we deal with our clients. Okay. So finally, we need to look at dealing with resistant parents as working to bridge between their autonomy on the one hand and their safety on the other. That's the crux of the issue. Whatever we may stand to get out of it by, for example, maintaining the value of their estate is secondary to seeing to it that they are able to live their life as much along the lines of how they want to live it as anything, and that their safety is uppermost in our minds, their physical safety, their emotional and spiritual safety, their financial safety. Those should be the number one issues. So for adult children, okay, um, we want our parents to stay in charge as long as their doing so can be done safely. So it may be that as long as there are trusted people assisting them, they can stay in charge, and we've bridged that gap between autonomy and safety very easily. Okay. We want to work to avoid court involvement in this, avoid disputes. Once these matters get into court, number one, they almost always become more difficult to solve because the judge is going to want to make sure he thoroughly understands what's at stake before making some kind of decision. And that will rarely happen in one or two hearings. Okay, it's going to mean there's going to be lengthy proceedings before the judge makes a decision, and that's prudent on the part of the judge. Okay, that's what judges are there to do. Also, the reality is litigation is expensive. Okay. The court costs may not be tremendously expensive, but if there's more than one lawyer involved, so, two lawyers being in court at the same time can easily cost $1,000 to $2,000 an hour, depending on what they charge. So they could charge four to $500 an hour is probably the base of what you will see a lawyer charge in this area. Here in California, I'm talking. Now, in other states, the fees are not that high. So if you've got two lawyers in court at kind of the lower end of this of the fee scale, $500 times two, that's $1,000 an hour that's being spent for those lawyers to be in court. Okay, that's a lot of money. It can very quickly defray an estate or cost you as adult children a lot of money to resolve issues. So you want to avoid court if you can. Okay, and you want to couch what you're doing for your parents just that way. We need to find a way to keep you safe while maintaining your autonomy, or at least as much of it as possible. That's what this is about. Okay. Now, for professional advisors, okay, we we want to align whatever solution we recommend as being the least restrictive. Number one. Number two, we want to recommend solutions that are going to prevent as well as possible disputes and keep everyone out of court. Okay. Now, some of you listening to this may say, well, that's not what lawyers do. Actually, in my experience, lawyers would rather stay out of court, especially lawyers in this arena. Going to court is a part of a lawyer's job, but it's usually the part they like the least because they get as frustrated with the system as we non-lawyers do. Okay, they would rather spend their time and charge their fees for making progress than showing up at a hearing only to have it continued, for the umpteenth time without anything of value really being accomplished. Okay, so that's kind of number one. Number two, we want to, as professionals, we want to make sure there's clear documentation with defined support roles. Now, in my situation, I'm not drawing up the documents, but I want to make sure that my role is clearly defined and that I have the guardrails I think are appropriate, and at the same time, I have enough authority to be able to fulfill my obligation, right? And so that's how a non-lawyer, for example, might get involved in this part of the process. And finally, as professionals, we can be most effective in dealing with these issues before cognitive decline sets in. Okay. And that's something we really need to keep in mind. We may need to, badger our clients a little bit. Hey, I really think you need to get this done. You need to think about these issues. We need to talk about them. We need to get your children involved. We need to get your spouse involved. Whatever it is that needs to be done, we need to be the one encouraging them. And it may take a lot of encouragement in order to get them to finally take care of it. Okay. So, real quickly, the 6 thoughts I have on dealing with resistive parents. First of all, understand why aging parents refuse help or resist help. 2, think about how you're going to approach the conversation. Make sure it's with empathy uppermost in your mind. Number 3, keep aware of the warning signs that legal risk is increasing. 4, look at tools that will add protection without taking over. And number 5, one strategic option is a limited conservatorship, okay, where it's limited in scope, it's limited in time, it's voluntary versus involuntary. All of these are possible ways of limiting a conservatorship. And finally, keep uppermost in your mind, and especially as you talk to an aging relative, that we're looking to maintain their safety and their autonomy, and we're looking for the balance or the solution that will allow that to be accomplished. So, thank you very much for joining me today. If you have questions, comments, criticisms, links to my social media will be in the show notes after the episode posts on YouTube. Feel free to post them there. If you have questions of a more personal nature, my email address is there as well. You can email me, keeping in mind I will address the question if it's within my area of expertise. If not, I'll recommend that you contact a lawyer, accountant, or whatever type of professional you need. Tomorrow at 10 a.m. Pacific time is my show, Business Lessons from the Military. On Wednesday at 10 a.m. Pacific is my show, People Making Money. And every other Thursday at 5 p.m. Pacific time is my show, Jiggers' Place. Meet me there for a cocktail and a schmooze. If you're watching this on Spotify or Apple Podcasts, please, if you like the show, drop a positive comment. I would really appreciate that. And that will help other people potentially find this as a resource to help them with these kinds of issues. So thanks again for joining me today. I wish you a wonderful rest of the day, and signing off as I always do. Marie, darling, you are my belle. Courage at all times, my friends.